From the U.S. Court of Appeals for the Third Circuit, we have another case on asylum law, and in particular, what persecution means. Hi, my name is Bill Kovatch, and I'm a trained immigration lawyer. So let me tell you that as a practitioner, there are times that I get frustrated when I see how law is being explained in the media. The legal pundits that you see on TV are not always true experts. And as an immigration lawyer, I would like to bring my knowledge and experience to you. So my goal is to present to you the actual texts of immigration decisions and explain to you what they mean and how they fit in the broader context of immigration law. The case we're going to talk about today is Ricardo Javier Blanco versus Attorney General, and it comes from the Third Circuit Court of Appeals. For those who need reminding, the U.S. Courts of Appeals are divided into 13 circuits, 12 of which are determined by geography. The Third Circuit hears cases that come from Pennsylvania, New Jersey, and Delaware, and the U.S. Virgin Islands. So in immigration cases, the appellate court to which you appeal depends very much on where the immigration court sits. I, for example, do much of my practice in Northern Virginia. I practice before the Arlington Immigration Court, and therefore, if I'm appealing a case beyond the Board of Immigration Appeals, I'm usually taking it to the Fourth Circuit that sits in Richmond, Virginia. Ricardo Javier Blanco, a citizen of Honduras, is a member of Honduras's Liberty and Refoundation, Libre, Party, an anti-corruption party that opposes the current Honduran president. After participating in 6 political marches, he was abducted by the Honduran police and beaten on and off for 12 hours. He was let go but received death threats over the next several months until he fled to the United States. He applied for asylum, withholding of removal, and protection under the Convention Against Torture. The immigration judge denied all relief, and the Board of Immigration Appeals affirmed. So as you can see, Blanco versus Attorney General is a very complicated case. It involves more than just merely asylum. It also involves withholding of removal and the Convention Against Torture. And because of that, we're going to concentrate solely on the asylum aspect of this case, and in particular, the persecution. Blanco now petitions for review of the agency's decision, arguing that the BIA and the IJ erred in denying his asylum and withholding of removal claims on the basis that his treatment did not rise to the level of persecution. Because the agency misapplied our precedent when determining whether Blanco had established past persecution, we will grant the petition, vacate the BIA's decision, and remand for further proceedings. So let me explain to you how asylum is supposed to work. You don't need to have entered legally. You don't need to have entered at a port of entry. You can have snuck across the border. You can be caught in the desert. You can decide to turn yourself into CBP. For that matter, if you're lucky enough to come across the border, get out of the desert, find yourself in a new city, you can apply affirmatively. You don't have to wait until you're in immigration court. Now, there is a requirement that everybody has to keep in mind, and that is that you need to apply within 1 year of coming into the country. There are some exceptions to that, but we'll explain those in a later video. So let's say you get caught as you're crossing the border, or you decide to turn yourself in to the nearest Customs and Border Patrol agent. Well, then you need to claim to the CBP agent that you fear returning home to your country. Once you've told the CBP officer of your fear, the CBP officer then has to contact the asylum office, and the asylum office is responsible for conducting what's called a credible fear interview. The point of a credible fear interview is to show that you are likely to prove your case before an immigration judge. So the asylum officer will listen to you and decide whether or not he believes that you meet that standard. If the asylum officer believes you have a credible fear, then you get sent to the immigration court where a date gets set for your immigration hearing. If the asylum officer does not believe that you have a credible fear, then you can appeal that decision to an immigration judge. The immigration judge is just looking at, do you have a credible fear? And if the immigration judge says no, well, then that's the end of your case and you get removed. Now let's say that the asylum officer says that you have a credible fear. Well, now you go to immigration court and it's time to prove your case. They'll set up a time and a date for your next hearing. You'll have time to try to collect documents and submit them to the court, and then you will testify before the court on your case. After you've had your hearing before the immigration judge, let's say it doesn't go in your favor. Well, then you have 30 days from the date that the judge issues his decision to appeal to the next level, which is the Board of Immigration Appeals. And if you don't like the decision that the Board of Immigration Appeals gives you, then you have 30 days to file another appeal, this time with one of the U.S. Courts of Appeals. Ricardo Blanco is a citizen of Honduras. Beginning in 2016, Blanco participated in 6 marches with the Libre Party, an anti-corruption political party. Blanco's 6th march was on November 27, 2017, the day after Juan Orlando Hernandez, whom the Libre Party opposed, won the presidential election. At that march, 4 Honduran police officers arrested Blanco, put a mask over his head, and took him to an abandoned house. They held him at the house for approximately 12 hours and beat him multiple times, for 40 to 60 minutes each time. During the beatings, the police threatened to kill Blanco and his family and warned him not to participate in any further Libre Party marches. They also used racial slurs against Blanco. After 12 hours, they left him in an abandoned lot. From there, he was taken to a hospital for evaluation. He did not have any bruises, cuts, or broken bones, and was given acetaminophen and released. Okay, so this looks like it's a setup for one of the 5 protected grounds. In particular, it looks like Blanco is looking for asylum based on his political opinion, or because they use the word racial slur, it could be that he's looking for protection based on race. The next day, Blanco learned that other march participants had also been abducted by the police, and at least one of them had been killed. He also heard from a neighbor that the day after the march, while he was staying at his mother-in-law's house, the police entered his home to look for him. Blanco remained in Honduras for about 14 months and did not participate in any further Libre Party activities. He moved from city to city, but the police continued to look for him and sent him threats. Specifically, Blanco received 3 letters and a phone call warning him that because of his political views, he and his family would be killed if they did not leave Honduras. Blanco also learned that some of the Libre Party members who had participated in the marches had been killed after receiving similar letters. The last letter Blanco received was in December 2018, and in January 2019, Blanco fled Honduras for the United States. His mother, young daughter, and daughter's mother remain in Honduras and, so far as the record shows, have not been harmed. So here's a reminder of what asylum is. Asylum is essentially protection. We're allowing somebody to stay in the United States in order to protect them because that person fears if they return to their home country that some really bad harm will come to them. And in order to get that protection, you need to have a reasonable fear of persecution based on one of the 5 protected grounds: race, religion, nationality, political opinion, and membership in a particular social group. Moreover, you need to show that the persecution is coming from the government or some force that the government is either unable or unwilling to control. Soon after leaving Honduras, Blanco was taken into custody by United States Border Patrol in Texas. Blanco informed Border Patrol that he was seeking asylum, withholding of removal, and protection under the Convention Against Torture. The asylum officer who interviewed Blanco found his testimony credible. So remember how I talked about the credible fear interview? That's what the Third Circuit is referring to here. The immigration judge denied Blanco's application and found him removable. The IJ found Blanco's testimony credible, except that his testimony regarding who sent the letters and made the phone call threatening him appeared to be speculation. Nevertheless, the IJ held that Blanco's experiences did not rise to the level of past persecution on account of his political opinion or race because, 1. His beating was not severe and did not end with any serious physical injuries, and 2. The officers did not follow up on their threats, and Blanco remained in the country for 14 to 15 months after the November 2017 incident and was not harmed again. The IJ also found that Blanco did not establish a well-founded fear of future persecution because it appeared that the police met their goal of preventing Blanco through intimidation from participating in any more political activities and did not follow through on their threats. So just think about what the immigration judge is actually saying here. First, you didn't get beat too severely. And second, you stayed in the country a good 14 to 15 months. So this fear must not have been immediate, except of course that the immigration judge is ignoring that during that 14 to 15 month period, the respondent here was traveling from city to city trying to stay a step ahead of his would-be persecutors. So the immigration judge is saying to Blanco that you don't have a reasonable fear of persecution here. And why? Well, it basically boils down to this. Look, they repressed you. And while they were repressing you, their goal was to keep you from engaging in the political process. So you were repressed. And you didn't engage in the political process anymore. So now that they've been successful in their repression, well, they're no longer going to repress you. So you don't have to worry about any future repression. They've already been successful in what they did in the past. This, by the way, is an attitude that we sometimes get from conservative judges when we have, say, a case that involves female genital mutilation. The idea being, okay, so they mutilated your genitals. They're mutilated. You can't have them mutilated again, so you don't have a fear of any future persecution. And this, quite honestly, represents the odds that immigrants and immigration lawyers are often up against. And why is that? Well, the immigration courts are not part of the judicial branch. They're actually part of the executive branch. They're in the Department of Justice, part of the Executive Office of Immigration Review. The Attorney General hires the immigration judges. Now, it's not supposed to be based on ideology, but that happens all the time. In fact, some immigration judges have as high as a 90% denial rate for people who file asylum applications, while other immigration judges have a denial rate as low as 30%. And since they are executive branch employees, they're not confirmed by the Senate. So that check and balance doesn't exist when we're dealing with the immigration courts. The immigration judges are ultimately answerable to the Attorney General. And this is why most practitioners will tell you that the system is rigged and that we really need to reform the system to make the immigration courts real courts, to make them part of the judicial branch and to take them out of the executive branch, because otherwise we're not going to get unbiased, disinterested opinions. On appeal, the BIA affirmed. It concluded that the harm Blanco experienced was more akin to harassment than persecution. The BIA also stated that Blanco had not established a well-founded fear of future persecution because he had not even shown that there is a 10% chance that a person in his position, that is a mere supporter of the Libre Party, who nearly 2 years ago participated in a few marches, would be persecuted upon his removal to Honduras. Okay, now let me tell you where this 10% comes from. There's a Supreme Court case that actually says that a fear is reasonable if there's a 10% chance that the persecution is going to happen. And that is a pretty low standard. So that is something that immigration attorneys like myself like to cite in our brief all the time. Keep in mind that the Board of Immigration Appeals is also part of the executive branch. It's also in the Executive Office of Immigration Review. There are 23 members of the BIA. All 23 members are appointed by the Attorney General. They are not confirmed by the Senate. And just like immigration judges, well, It's not supposed to be based on ideology, but in reality, you get people who are members of the BIA who routinely find ways to find against the immigrant. The Trump administration, for example, has attempted to pressure a number of BIA members that it didn't like to go into early retirement. And the Attorney General has elevated immigration judges who had a record of finding against the immigrants or of appointing people like people who run the chief counsel's office for the Department of Homeland Security to the level of a member of the Board of Immigration Appeals. The deck is very much being stacked against the alien. In fact, it's possible for one member of the board to decide that a case is appropriate for something called a summary affirmance, an affirmance without an opinion. Now, sometimes you may get 3 members on a panel deciding a case, but very often it's just one judge. You have the luck of the draw in a deck that's stacked against you. To establish asylum eligibility, a non-citizen must show that he is a refugee within the meaning of the Immigration and Nationality Act. A refugee is a person who is unable or unwilling to return to his home country because of past persecution or, in the alternative, a well-founded fear of future persecution on account of a protected ground, race, religion, nationality, membership in a particular social group, or political opinion. The non-citizen must also show that the government in his home country either committed the persecution or was unable or unwilling to control the persecution. Blanco argues that the BIA and the immigration judge erred in concluding that he did not establish past persecution or a well-founded fear of future persecution to support his asylum and withholding of removal claims. We agree. So if you saw our analysis of the Fifth Circuit case that looked at persecution, you can see a definite difference in the tone in which the court brings to this analysis. The Fifth Circuit was definitely more conservative and more deferential to the Board of Immigration Appeals. But when it comes to the Third Circuit, well, they're saying we have our own rules of what persecution is, and we're going to make sure that the BIA follows our rules. And this brings us to an interesting point. There is one Board of Immigration Appeals. It sits in Falls Church, Virginia. In fact, it's not too far from where I live and practice. So whenever I had a case that involved an appeal to the BIA, I would deliver all my papers personally to the BIA to make sure it arrived in time. But the point is, we have one Board of Immigration Appeals, but we have 12 circuit courts who can hear appeals from that administrative agency. And as we've just discussed, some circuits are notoriously conservative, such as the Fifth Circuit, where Texas lies, sometimes the Sixth Circuit, where Ohio lies, and some circuits are known for being very liberal, such as the Ninth Circuit, which sits in California and encompasses most of the western United States. So it is very much possible that you could have 12 different rules on the same subject, and the BIA has to apply one of those 12 rules based on which circuit the case belongs to. To show that he is eligible for asylum because of past persecution, Blanco must demonstrate that what happened to him rises to the level of persecution. Persecution does not encompass all forms of unfair, unjust, or even unlawful treatment. Rather, we have defined persecution as including threats to life, confinement, torture, and economic restrictions so severe that they constitute a real threat to life or freedom. To determine whether an experience rises to the level of persecution, we must look at its cumulative effect, because taking isolated incidents out of context may be misleading. Persecution may be actual or threatened. Even if one incident of mistreatment is not, in and of itself, severe enough to constitute persecution, a series of incidents of physical or economic mistreatment could, taken together, be sufficiently abusive to amount to persecution. So the point here is that one event may not itself be persecution. Let's take a racial slur. If somebody says a racial slur one time, that's not persecution. But the court is saying that we can't look at just that one incident. We need to look at everything to see if cumulatively it all adds up. That is, look at it all in the aggregate. Take all of the facts and circumstances into consideration. And after we've looked at all of the facts and circumstances, if we see something that's bad enough, that's a threat to life or liberty, well then together it's considered persecution. In this case, Blanco's past harm includes the November 2017 abduction and beating and the series of threats that followed. The BIA and IJ misstated our precedent in 3 ways when determining whether this harm rose to the level of persecution. First, by requiring Blanco to show severe physical harm in order to establish past persecution. Second, by requiring death threats to be imminent. And third, by considering the beating and death threats separately. Okay, so if you're a budding law student, I want you to pay particular attention to what the court has just done and what the court is doing in its opinion. This is classic legal writing. And what you do in classic legal writing, you state your rule. Then you talk about the facts, particularly as the facts and the rule interact. And then you come with your conclusion. How does the rule apply to the facts that you've just stated? If you're going to be a successful lawyer, you need to master that skill of presenting your argument in a cohesive fashion. Law, facts, conclusion. This court does not condition a finding of past persecution on whether the victim required medical attention or even whether the victim was physically harmed at all. We have never reduced our persecution analysis to a checklist or suggested that physical violence or any other single type of mistreatment is a required element of the past persecution determination, nor do we measure the severity of an injury in stitches. However, that is exactly what the BIA and immigration judge did here. The IJ stated that although Blanco was mistreated, the beating was not severe and did not end with any serious physical injuries. The BIA agreed, noting that Blanco required only Tylenol to treat his physical injuries as opposed to stitches, surgery, or prescription medication. So the point here is that persecution can't be boiled down into a simple rule. The problem is that the human mind is just way too inventive in ways that we can harm each other. So the court doesn't want to predefine what kind of actions constitute persecution. In fact, if you think about it, economics can even become persecution if you're preventing somebody from getting a job, for example. The question is whether the actions, whether all these actions in the cumulative add up to a danger to somebody's life or liberty. The IJ relied on our prior holding that an isolated incident that does not result in serious injury does not rise to the level of persecution. However, setting aside the fact that Blanco's abduction and beating was not an isolated incident, it was followed by 4 death threats, we have never defined serious injury to mean serious physical injury. So the court here is telling us that the BIA was being too formalistic. This was not an isolated incident. In fact, the court here is making the point that you don't need a physical injury at all. Economics can be persecution. Mental injuries can be persecution. Death threats alone can be persecution. You don't really need to act on the death threat in order for it to be called persecution. For example, in Chavarria versus Gonzalez, we held that death threats that cause significant actual suffering or harm are cognizable forms of persecution. Chavarria's death threat, in light of his experience of being forced from his car and robbed at gunpoint, rose to the level of persecution. Furthermore, we have since clarified that Cabinda did not foreclose the possibility that outrageous conduct, even if limited to a single event without physical harm, could rise to the level of persecution, as was the case in Chavarria. Thus, our precedent demonstrates that physical harm is not dispositive in establishing past persecution. The BIA and IJ erred in requiring that Blanco show physical harm, much less severe physical harm. So, U.S. law is derived from English common law. We have something called stare decisis. It's a principle that a case that's been decided then applies to future cases. It sets the rule. But you can get into a very detailed analysis. Was that prior case exactly the same as this case? Are there reasons that distinguish that case from the case that we have? Is that case worse than the facts we have? Or maybe the facts from that case are better than the facts we have? The court here is going into the details and the facts of prior cases and comparing it to what happened to poor Mr. Blanco to see if it meets their standard of what persecution is. The BIA and IJ next erred by requiring that the threats Blanco received be imminent in addition to concrete and menacing. This is not our standard for assessing whether threats are sufficiently serious to constitute persecution. We noted that it is true that we have sometimes used the phrase highly imminent, concrete, and menacing. More frequently, however, we have used the terms concrete and imminent interchangeably or in the disjunctive. That, we explained, is with good reason. Imminence is a misnomer here. In actuality, we have neither required that the threat portend immediate harm nor that it be in close temporal proximity to other acts of mistreatment. The key is not the threat's imminence, but rather its likelihood, which is subsumed in the inquiry as to whether the threat is concrete. For these reasons, we announce that we will refer to the standard going forward simply as concrete and menacing. Words matter. Courts can get very particular in their legal standards. I've seen it where a court or a lawyer will break out a dictionary in order to parse out a very precise definition or find an obscure definition for a particular word that's used in a statute or in a legal opinion. It could be that the courts or the lawyer is looking for the slightest bit of ambiguity or an area that can have more than one meaning in order to argue that this is what the rule says or this is how the rule should apply in this particular case. Now keep in mind that the courts of appeals could have 9, 11, 13, 21 judges who sit on the court. But that doesn't mean that they're involved in all of the cases. Cases are usually heard by a 3-judge panel. And since you have that variety and diversity in all the judges who may be able to write an opinion for the court, sometimes you have judges who go off in different tangents or say things that aren't as precise as an earlier judge. In fact, in many instances, it's not even the judge who writes an opinion. The judge has a law clerk, and the law clerk will take the first draft at writing an opinion, and the judge merely edits or gives suggestions on how the law clerk should finish it. So sometimes, subsequent panels need to clarify things that maybe an earlier panel either got wrong or didn't say as precisely as they should have. A threat is concrete when it is not abstract or ideal, but is corroborated by credible evidence. A threat is menacing when it shows intention to inflict harm. In sum, a threat that is concrete and menacing is simply one that, considered in the context of the full record, poses a severe affront to the petitioner's life or freedom. Both the BIA and the IJ repeatedly emphasized that despite the death threats, Blanco remained unharmed in Honduras for over a year. As is clear, however, a threat need not be acted on to constitute persecution. In a similar case to this one, where the threats were unfulfilled and the petitioner fled his home country, we wrote that to expect a petitioner to remain idle in that situation, waiting to see if his would-be executioners would go through with their threats before he could qualify as a refugee, would upend the fundamental humanitarian concerns of asylum law. Indeed, if Blanco's persecutors had followed through with their threats, as the BIA and IJ seemed to suggest was necessary, Blanco would be dead. Yeah, seriously. Take a look at the way the BIA is saying this. What they're essentially saying is that, well, that death threat wasn't really serious because they didn't act on it. But that creates an impossible standard, because they're saying that in order for you to qualify for asylum based on a death threat, the death threat had to be acted on, which means you have to be dead. The threats Blanco received were both concrete and menacing. Others who attended the Libre Party March had been killed, and some of those victims had received threatening letters like Blanco's beforehand. This demonstrates the likelihood of the harm threatened. Furthermore, the threats were concrete because, as Blanco credibly testified, during the 14 months after the November 2017 incident, he fled from city to city as the police continued to look for him. The threats were also menacing because they expressed the intention to kill Blanco and his family if he did not leave Honduras. So you may remember when we talked about the case out of the Fifth Circuit, what was called Yatani. Well, back then I said that it seemed to be a very significant point that Yatani waited 6 months before he left his country of Albania. Well, here we have an applicant who didn't leave his country until 14 or 15 months after he was physically harmed. So what's the difference here? Well, the difference is significant. Yeah, it's true that Blanco stayed in Honduras for 14 to 15 months, but he didn't sit around doing nothing. He went from city to city trying to hide from the police, who all the while were tracking him down and sending him messages to his new residences of, hey, we're still going to kill you. We're still going to kill your family. That's not the same as sitting around for 6 months doing nothing and then finally coming to the United States. He's trying to stay a step ahead of his would-be persecutors. Thus, the BIA and the IJ erred by not applying the proper standard under our precedent in evaluating when threats suffice to establish persecution. Lastly, the BIA and the immigration judge erred by failing to consider the aggregate effect of Blanco's mistreatment. In determining whether an asylum applicant suffered past persecution, the agency may not take a single instance of mistreatment from a larger pattern of abuse and confine its persecution analysis to the question of whether that single instance was, in and of itself, persecutory. Instead, incidents alleged to constitute persecution must be considered cumulatively. Even if one incident of mistreatment is not, in and of itself, severe enough to constitute persecution, a series of incidents could, taken together, be sufficient abuse to amount to persecution. Thus, each incident must be assessed within the overall trajectory of the harassment. Moreover, a cursory invocation of the word cumulative is insufficient. Even if the agency is correct that no single incident in isolation rose to the level of past persecution, it is still required to analyze whether the cumulative effect of these incidents constituted a severe threat to life or freedom. In Herrera Reyes, for example, the immigration judge erred by finding it dispositive that the petitioner herself was never physically harmed and by failing to factor in the cumulative effect of the destruction of her home, the shooting of her convoy, the murder of her political compatriot, the armed robbery of the inauguration preparations, and the verbal death threat. There appears to have been a difference between what the BIA did and what it said it was doing when it analyzed the cumulative effect of Blanco's experience. It paid lip service to the notion of cumulative analysis, stating that it was looking at past harm considered cumulatively, but it also said that the harm was more akin to harassment, emphasizing that events commenced with an isolated incident of physical harm. The BIA and the IJ did not consider how the surrounding acts of mistreatment, the abduction and beating by the Honduran police, and Blanco's testimony regarding other Libre Party protesters who had been killed, corroborated the death threats that Blanco received. Thus, as in Herrera Reyes, although the agency purported to consider the incidents cumulatively, in practice it evaluated the harm to Blanco in isolation without accounting for the broader campaign of intimidation, harassment, and violence substantiated by the record. Although Herrera Reyes is factually different from Blanco's case, at bottom it addressed whether and under what circumstances threats of violence may contribute to a cumulative pattern of past persecution when not coupled with physical harm to the asylum seeker or her family. To this effect, we noted that in evaluating whether a threat is concrete and menacing in the absence of physical harm, we have considered more broadly whether surrounding acts of mistreatment had corroborated that threat with the ultimate effect of placing the petitioner's life or liberty in peril. In Herrera Reyes, we concluded that the incidents the petitioner experienced reflected an escalating pattern of mistreatment that culminated in a final death threat, and that final death threat was concrete and menacing considering the context in which it was given. That context was the fact that the petitioner was the leader and president of an opposition group to the Nicaraguan government who experienced verbal threats, the burning of her family's home, the murder of her close compatriot, and the robbery of her workspace at gunpoint. The 4 death threats lodged against Blanco were, of course, not received in an identical context. The most important differences are that Blanco was not a high-level leader of the Libre Party, and the record does not reflect that he was a close associate of members of the Libre Party who were killed, though he did learn that some were killed after receiving similar threatening letters. Nevertheless, the incidents Blanco experienced reflect an escalating pattern of mistreatment sufficient to rise to the level of persecution because Blanco, unlike Herrera Reyes, suffered physical harm, the November 2017 abduction and beating, in addition to receiving threats of violence. Furthermore, unlike Herrera Reyes, the death threats Blanco received were also directed towards Blanco's family. Ultimately, while Herrera Reyes is instructive to our analysis, we must remember that it addressed under what circumstances threats of violence may contribute to a cumulative pattern of past persecution when not coupled with physical harm. Thus, the factual differences between Herrera Reyes' case and Blanco's case become less significant when one considers that Blanco's threats of violence that contributed to a cumulative pattern of past persecution were coupled with physical harm. We think that it is appropriate to conclude that it was more important to Herrera Reyes' past persecution analysis that she was a leader of her political movement and that she was close associates with the political activist who was murdered because Herrera Reyes could not show any physical harm. But here, Blanco's threats of violence were coupled with physical harm, and that suffices to establish past persecution in this case. In sum, the BIA and the immigration judge erred when they held that the harm Blanco experienced did not meet our legal standard for past persecution. Upon application of the proper standard, it is clear from the record that Blanco had established past persecution. We will remand to the BIA to consider the other 2 elements of the asylum eligibility. That is, whether the persecution was on account of a statutorily protected ground and whether it was committed by the government or forces the government was unable or unwilling to control. Okay, so thank you for watching it. I know this was a long video. Thanks for making it all the way through. I hope that we were able to explain better how asylum law works. I know it's a very complicated subject. Hopefully we've been able to shed some light on it. So I hope you enjoyed it. If you did, please do give us a thumbs up and let us know in the comments below. What did you think of this video? Are there other topics that you may want to see in the future? Are there other decisions that you may not understand and you'd like for us to explain? Thank you for watching. Please remember to like and subscribe. If there are any topics you would like me to address in the future, please let me know in the comments below. Now, I don't like talking about this, but I am currently disabled because of complications following cancer surgery. If you're feeling generous, I'll have a link to my PayPal account in the description below. Thank you.